everyone. I'm Werner Lowy, the hearing officer in this case. We're here for the second day of hearing in the case of Surfside Crossing, LLC versus Nantucket, number 2019-07. Before anything else, let me ask our stenographer, Ms. Blankenship, have you been able to get whatever information you need from counsel about transcripts, or would you like to do that now?
I could do that now. That'd be great. Mr. Pucci, would you be ordering a copy of the transcript?
Yes, please.
Okay. And there was another attorney here yesterday as well for the neighbors.
Braun, she's working with on the same firm. There would be just one transcript ordered for both of us.
Okay.
She represents the board as well.
Okay. All right. Thank you. And I know that Mr. Haverty.
There's also attorneys Murphy and Durensis. I don't know if they want transcripts or not.
Okay. Are they on right now?
I believe they are. They're representing in the interest.
Oh, that was. Are you ordering a copy of the transcript?
Hi, this is Paul Durensis. Probably. I just have to check with the client. I forgot to ask that.
If you could just let me know, I'd appreciate it.
Excuse me, this is Peter Fenn. I see Mr. Murphy has not come on. He's our attorney. I don't know if he's on yet or not, but we will want a transcript.
Okay, thank you.
Thank you, Peter.
Yep.
That's it. Thank you very much.
Mr. Lowy, you're on mute.
You need Mr. Murphy's address or anything, or are you all set? I guess we're all set.
We'll get it to you if you need it.
Great, thank you. All right, so this morning we'll start with the with redirect of Mr. Feely, but is there anything preliminary that we need to discuss before we do that, or should we jump right in?
Nothing from the applicant, Mr. Hearing Officer.
Fine, hearing nothing, then Mr. Haverty, why don't you begin your redirect? I'll remind Mr. Feely that you're under oath still.
Thank you. Good morning.
Good morning.
Good morning, Mr. Feely.
Good morning, Mr. Haverty.
Mr. Feely, during your cross-examination, you were asked several questions regarding the density of other developments in Nantucket. Do you recall this line of questioning?
Yes.
And have you had an opportunity to review the density of any other developments in Nantucket?
Yes.
And can you describe the density of those other developments?
I can. Would it be all right if I just reference the notes that I took?
Mr. Lowy, I object just in terms of the scope, other developments. What are we talking about?
Comparable,
Just a second, Feely. Mr. Haverty, you want to address that?
Again, there was testimony that was elicited during cross-examination yesterday that asked about the scope of different developments within the town of Nantucket, and this is a follow-up to that testimony.
The question was general. I addressed specific projects yesterday, most importantly limited to 40B projects, and this is redirect, and he's limited to the scope of the cross-examination.
Right. Well,
and the cross-examination included discussions of Tacoma Green and other developments in Nantucket.
I'm going to overrule any objection. It's a perfectly proper area of inquiry on redirect, since on cross there was discussion not only of density of things in the immediate vicinity, but also well afield throughout Nantucket, as far as I could hear. And I would also point out, Mr. Bucci, that Mr. Haverty asked a fairly open-ended question because it's redirect. And if you would, I believe that's a more appropriate way. If you want him to be more specific, sometimes there's questions you can, but let's start this over, Mr. Haverty.
My point, Mr. Lowy, is only that he's limited to the scope of the cross-examination. And the developments that I addressed yesterday were not far afield of this development. They were analogous 40B or related extra zoning allowed projects that are in a reasonable comparison to the project at issue.
My recollection, Mr. Pucci, is that he discussed a large number of projects, not just 40Bs or just ones immediately by there, that those were things that you elicited on cross, and that the general area, he's not limited just to the particular developments that may have been discussed yesterday, but that the whole area of inquiry is relevant. So please go ahead, Mr. Haverty.
Thank you. So, Mr. Feely, again, can you describe the various densities that you've had the opportunity to review in Nantucket?
Yes. Is it okay just to reference my notes?
Mr. Pucci, would you like to see the notes? Would you?
Yeah, I object to that. No, I don't want to see the notes, and I object to him using notes to read from for testimony. In effect, it's violating the rule for the pre-filed testimony. I've had no chance to review this either by myself or with relevant witnesses. It's a new document. No notice was provided, contrary to the notice that I provided more than a week prior to the hearing, and I object to it. He can testify to his best memory to things, but he cannot read from documents which are not in evidence.
Thank you. I'll sustain that objection and ask Mr. Feely if you would please testify from memory, not from any document you've prepared since yesterday.
Sure. So I did look at Richmond Group, which is a development not that far from the project, and probably 2 or 3 miles. And it's broken up into different areas. It includes some commercial and some industrial facets to the overall project, and has residential areas. One of them is Meadows 1, there's Meadows 2, there's an area referenced as Sandpiper, and some of them have freestanding units, some of them have apartment buildings, but they are all more dense than what we had proposed. I think the density of one of those areas is 15 units per acre. One of them was 17 units per acre. We looked at the recently approved project on Fairgrounds, which was, I think it's 24 units on 2 acres. So I'm sorry, I was kind of expecting to be able to use my notes, but we looked at the Vestal Street project, the Fairgrounds project. The Vestal Street project, by the way, has not been approved yet. It's been proposed by the Nantucket Affordable Housing Trust Fund. We looked at, and those projects right there.
I object, Mr. Lowy, to anything that is not approved yet. As you noted yesterday, although I corrected you about the speculation as to the future permitting has no relevance in this.
Your objection is overruled, and you may delve into that on recross, Mr. Pucci.
Okay, so there was
Mr. Feely, and you can let Mr. Haverty ask another question, if you will.
Thank you, Mr. Chairman. I'm sorry, Mr. Hearing Officer. We can move on. So yesterday you were asked about the project as currently proposed and whether it would require a height waiver. Is that correct?
Yes.
And have you had the opportunity to review your response to this question?
Yes.
Okay, and what exactly did you determine in that review?
So from the grade up, the height of the tallest building is 30 feet 2 inches. And at one point in the process, there was a grade averaging that was done for this plan, which takes into account the grade alterations for the walkout lower level. And as a result of that, and in accordance with the local bylaw, it was recalculated to 32 feet 6 or 7 inches. And so that's the reason for the waiver.
All right, so there would be a slight height waiver required for the current proposal?
Yes.
Okay. And you were also asked a question about the economic viability of the 92-unit development reviewed by the board. Can you explain how this proposal came to be before the board?
So the 92 unit, at the time we were pretty well into a 100-unit plan that was in front of the board that we'd spent a lot of time reviewing, that was becoming apparent we weren't going to find common ground on. And so prior to closing the hearing, as it related to that last plan, they had requested that we participate with a town consultant, architectural consultant, and see if we could find another plan or another version that might find common ground. And so we did. And so that 92-unit plan was the result of that work group led by Cliff Bomer. And it was never a plan that, came from us or that we were particularly excited about, but it was a good faith effort that we were willing to participate in.
Okay. And in your opinion, would the 92-unit approval be economically viable if all of the conditions the board imposed in its decision, leaving aside the number of unit restriction, would that result in an economically viable project?
No.
Why not?
Well, because it's been 2 years of appeals costs and, reworking the plan, and however long it will continue to go on from here, including the additional conditions that the board had imposed, including the surety bond for the infrastructure at 150% of that cost, the curbing, the many marketability restrictions that they had imposed. So,
okay. You were also asked during your cross-examination about the plan depicting the project approved by the board that was prepared by Bracken Engineering. Did you instruct Bracken Engineering to prepare a plan depicting only 59 units?
No.
Did you add any constraints to the design parameters outside of the conditions imposed by the board?
No, only to use the road layout that was a part of it. The 90.
Okay. Thank you. Ms. Loftus, can I have you put up Exhibit 2, which is the ZBA's decision?
One moment, please.
Thank you. And I'm looking for page 13. Yeah, that's good. Mr. Feely,
Yes.
can you see condition 13J on the screen right now?
Yes.
All right. So during your cross-examination, you were asked whether the board's decision allowed the construction of 5 5-bedroom homes or 4 5-bedroom homes. What is the maximum number of 5-bedroom cottages allowed by the board's decision?
4.
Thank you. All right, we're all set with that, Ms. Loftus. Now, your pre-filed testimony includes a cost for granite curbing imposed by the board's decision in the amount of $877,059. Can you explain how you determined this figure?
Yes, we came up with lineal footage for a general lineal footage for the project, and then we talked with Don Bracken, who's our engineer, who has access to national standards books as far as what the cost would be for granite curbing on a lineal foot basis. And in the 2017 edition, it had pricing at $35 a square foot, or $36 a square foot for a straight run and $44 for curved pieces. And we did our calculations and came up with that number, a number, and then added a contracting fee to it, and that's where we came up with that number.
Okay. And there was also a discussion yesterday regarding traffic mitigation of $200,000. Was that figure based upon a 60-unit development or on the 156-unit development?
The 156-unit development.
So would $200,000 represent a fair mitigation cost for the impacts associated with the 60-unit development?
It would be disproportionate.
Thank you. And you were also asked questions yesterday regarding fire safety, correct?
Yes.
Was fire safety a concern of yours with regards to this development?
Of course. That's why we hired Code Red, one of the top fire safety consultants in the Commonwealth.
Okay, and the determination from Code Red, did they determine that you complied with all state and local requirements?
Yeah, so we had direct interaction with the local fire department throughout the process, going back to the earlier plans. And we met with, on this latest plan, we met with Joe Townsend, who's the fire prevention officer, and Don Brackett and myself met with him at the fire station, and we got some specific feedback, including adding a couple fire hydrants and eliminating some parking spots in order to, address a couple access issues, all of which we made. And then reviewing this same plan later with Jeremy Souza from Code Red, he came up with some additional concerns that actually had to do with ladder access. And he said, look, there's 5 of these buildings that are on the margin. And so what I would recommend to completely address that issue would be all of your buildings, of course, are sprinkled. But if you change the sprinkle system in these buildings to a more robust system, and it's in his testimony, we can look up the exact term relative to the standard that he had us go to, which we did, and we committed to through his testimony that would address.
Okay. So Ms. Loftus, can you please put up Exhibit 37 onto the screen?
Yes. I'm sorry, you said 37?
37, correct. It's a pre-filed testimony of Jeremy Souza. And we're looking for paragraph 25.
Precisely.
Right, so paragraph 25 of the pre-filed testimony of Jeremy Souza, does that discuss the NFPA 13 sprinkler systems?
NFPA 13, exactly correct.
And which buildings are those being proposed to be included in?
In buildings 1, 8, 10, 14, and 18.
All right, and you were asked questions yesterday regarding the testimony from Fire Chief Murphy, correct?
About the testimony of Fire Chief Murphy, yes.
Does Chief Murphy's pre-filed testimony indicate specific structures that he would not be able to access with an aerial ladder?
No.
But we presume it's these buildings 1, 3, 8, and...
Yes, and Jeremy was very conservative in his approach. So if there was anything that was even marginal.
Excuse me, is there objection, Mr. Peely? I'll sustain the objection.
Okay.
All right. So, Mr. Feely, how did you determine that the projected sales prices of the market rate cottages for the board's project would range from $1.65 million to $1.95 million? Was this based upon a comparison with recent sales from the Beach Plum Village project?
It is. We performed a comparison and corrected to get to an apples to apples comparison, yes.
Okay. I believe you stated yesterday that the comparison to Beach Plum Village units approved by the board was an apples to oranges comparison, and that you had to make adjustments.
Yes.
To make it more of an apples to apples comparison.
Yes.
What adjustments did you make from the Beach Plum Village units as compared to the units for the project?
So we talked about, so there's three aspects is when we were doing the valuation of the project, and one is kind of the quantifiable elements of a property, which is the neighborhood, the size of the structure, the size of the lot, all the stuff that you can generally get from paper. Then there is the potentials for that property, as far as, you know, how you can expand it, what you can do, what are the limitations, and then thirdly, there's kind of the emotional impacts that might come from the finishes and the designs and the views. But in any event, in our analysis, we considered the furniture. A lot of the units that had sold in Beach Plum Village were fully furnished by a professional designer, interior designer with high-end furnishings. Many of them had spas, which would be an add. Let's see what else. Actually, do you have that chalk? Can we reference the matrix that?
So I will ask about that. Mr. Hearing Officer, the witness has prepared a chalk that discusses the adjustments that were made. I'd like to share that if I could.
I object.
What's your objection, Mr. Pucci?
It violates your own rules. I provided the comparable sales evidence more than a week before the hearing, which is in accordance with the regulations and in accordance with your pre-hearing order. This is new evidence, and I haven't received notice of it. It also addresses issues. There's no argument that it only comes up because of cross-examination, because this issue was raised in Mr. Feely's pre-filed testimony. And he testified specifically in that pre-filed testimony as to why he believed that the Surfside units were less marketable than the Beach Plum units. And he was free to submit any information in support of that he wished. And if they thought it was inadequate, they could have given me more than 7 days notice, and not just notice today at the hearing. They didn't even give me notice last night that they intend to introduce anything new.
Mr. Hagerty?
And Mr. Hearing Officer, the intent is not to introduce this as an exhibit. It's simply to use it as a chalk to allow Mr. Feely to go through the adjustments that he made.
I object. It's not evidence.
Excuse me, Mr. Pucci. Mr. Pucci. I'll sustain the objection. Again, if nothing else, my view is that, particularly in this kind of in an informal hearing setting here, it would be within my discretion to admit it. It's not like in a courtroom, but I think in general, we should not have chalks. If it's important, it should be an exhibit. And since Mr. Pucci hasn't had a chance to look at it, I'm going to sustain his objection.
Right, thank you. Mr. Feely, did you make any adjustments to any of the Beach Plum Village sales based upon the fact of those units having spas?
Yes, I made a $75,000 valuation correction to the units that sold with spas.
And do you recall which units had spas?
One Blazing Star, let's see, 3 Woodley, you're talking of all of the units that I used over the course of the year from 9/24/19 to 9/24/20, or
correct?
Okay.
And I object, Mr. Lowy. It's not relevant to the time period. Your effective date is September of 2020, not 2019. Nowhere near 2019.
Overruled. Again, these dates are in a general range. If you want to pursue that, you can pursue it on recross.
Thank you.
So, okay. Mr. Feely, did you make any adjustments for any of the units having garages from the Beach Plum Village development?
Yes.
And what was that adjustment?
That's $150,000 for two car garages.
And do you recall which units had the 2-car garages?
4 Blazing Star and what was the other one? On Thistle Way, I think one of the Thistle Way, 4 Thistle Way, I believe.
Okay. And with regards to the furnished houses, do you recall what your adjustment was with regards to fully furnished houses?
$150,000.
Okay, and do you recall which of the Beach Plum units were sold as fully furnished units?
Most of the ones that had the higher price points. But let's see, one Blazing Star was, or excuse me, 2 Blazing Star, 4 Blazing Star, 3 Wood Lily. I think 1 Wood Lily is on there.
Okay. And did you make any additional adjustments for restrictions contained in the board's decision?
I did. We made 2 adjustments for the board's restrictions, which include not expanding the footprint, not finishing any unfinished spaces, not expanding any impervious surfaces, which we interpreted as patios, limiting the types of plants that you could, vegetate the property with, the gravel you would be required to use in the driveway, the apron. So it took a lot of the potential out of these properties and what somebody could do after moving into it. Essentially, you'd have to move in, accept it as is, and that's going to be it from an exterior standpoint. And so we adjusted $50,000 for that.
Okay, and sorry, was there an objection there? Okay, Mr. Feely, did you include any other adjustments?
One other, we adjusted for unfinished basements where several of the units had unfinished basements that were essentially ready to be finished. They have window wells and in most instances egress window wells. Some of them had underground plumbing in it for the potential for future bathrooms. In a couple instances, the basement was actually permitted to be finished, and then it wasn't actually finished. So, and in those instances where there was roughly 1,000 square feet of basement to be ready to be finished, we included a $50,000 adjustment for that space. Okay,
and so do you recall what the adjustments for the average 3-bedroom unit was? The adjusted price?
The adjusted average for the 3-bedroom was 1.675.
Okay, and do you recall what the adjustment was for the average 4-bedroom unit?
Yes, I do, but it's interesting because we ran it 2 ways. We actually added Mr. Pucci's latest beyond the 924 cutoff. I think he had three units that had sold after that time that we included. So I have 2 different averages in my head, but one of them is right at 175 and one of them is just over 175 for the 4 bedrooms. 1765, I think, when we included Mr. Pucci's most recent, which averaged it up.
All right, so that's sort of going to be the next question. You were asked to review a list of confirmed sales.
I'm sorry. Actually, as I recall, it was 1765 without Mr. Pucci's, and it was 1777 with Mr. Pucci's.
Okay.
Those are all like, you mean it's 1.7 million?
Yes.
So you were asked to review a list of confirmed sales for 2020 and 2021 as part of your testimony yesterday, correct?
Correct.
And how many sales were listed on this document?
7.
Of the 7 sales, how many occurred prior to September 24th, 2020?
4.
So that means 3 of the sales occurred after the effective date of your testimony?
Yes.
Okay. So did you use sales data from after September 24th, 2020 in your estimate of the sales prices of the cottage units?
No.
Okay. You testified yesterday that you reviewed sales data for a period of 1 year prior to the effective date of your estimate, correct?
Correct.
Why did you use this date range?
Because that's the standard approach that I would take in evaluating a property.
Okay, and that's based upon your experience both as a developer and as a real estate broker?
Yes.
Okay. Is the 60-unit development that the board did approve one that is consistent with your development intentions for the property?
No.
Why not?
Well, because when I was first asked by Mr. Posner, my partner in this, if I wanted to get involved in a project after Beach Plum Village, a 40B type project that would address housing, my answer was yes, and it was qualified. And as much admiration as I have for Josh and for the project he did at Beach Plum Village, my interest in doing a similar type of project I wanted to have more of a impact on the year-round housing beyond the low income piece of it. And so if we were able to come up with a project that could create a market rate option for year-round Nantucketers in that price point, something I would be interested in investing the time and energy and being a part of. And so that's kind of the basis on which we got involved in what has now evolved into the Surfside Crossing project. And so as part of doing our research on what can we do that would fit into that price point, we narrowed it down to condos as the only way to create a product between $450 and $850 or $825. Now it's evolved to $475,000 to $825,000 as that middle market piece that is specifically designed and finished to hit a market that's affordable to the year-round folks of Nantucket.
Thank you. Why did you insist on closing the public hearing before the board without allowing time for further review of the 92-unit development?
Because at that time, it was my impression that the board was not interested in approving that project. They were still very much focused on finding ways to reduce the number beyond the 92. And when we entered into that work group and agreed to be a part of it, it was always stated that, look, there's just the 100-unit plan is right at the precipice of being economically viable. So there's just not going to be a lot of room for significant reduction. And when we got down to the 92 version, it didn't seem to be enough. And so that's why we decided it's time to close it.
And would a 92-unit project be viable now?
I checked. We covered that already.
Mr. Hearing Officer, I don't believe we've covered whether the 92-unit project would be viable currently.
You asked the same question.
Excuse me, Richard. My real question is whether it's relevant or not. Mr. Haverty, why is the 92-unit relevant?
Well, it was discussed during testimony yesterday. Mr. Hearing Officer, if you believe it's not relevant, I'll withdraw the question. Mr. Feely, I'm sorry, go ahead.
Thank you.
Okay. Mr. Feely, you were asked during your cross-examination about the significant opposition the project has encountered. Can you explain how this level of opposition has impacted you as a resident of Nantucket?
Sure. So I testified yesterday about how I went into this with a certain expectation about, this is going to be controversial and is likely not to be a perfectly pleasant process, and it has proved not to be, and to some degree greater than I had expected. But I'm really fortunate that my wife is a licensed social worker here in Nantucket and understands the needs and has been very supportive of my involvement and but it has affected, I think, or been, tough on us and the family. But, there's a whole faction of Nantucket that is being affected by the current circumstances around this need. And I am in a unique position where I work with essentially the entire socioeconomic.
I object now. I think we're getting a little far afield of personal knowledge, Mr. Lowy. The question was irrelevant. For personal interest, I didn't object, but I think we're going a little too far now.
Mr. Pucci, I'm going to overrule the objection because it seems to me you opened similar lines of inquiry yesterday with regard to people attending public hearings and different things. And there was no objection then, and I'm not sure how relevant it was then, and I'm not sure how relevant it is now. So I would do this, which is, Mr. Feely, I ask you to wait for Mr. Haverty to either ask a new question or repeat that question, whatever he wants to do. But I would ask both of you to limit your discussion of this, because I'm allowing it only because it was gone into yesterday, and I see the relevance of it as quite limited, if there's any at all.
Thank you, Mr. Hearing Officer. I think that's enough. I have no further questions.
Mr. Pucci, recross.
Thank you, Mr. Lowy. A number of questions. For Mr. Feely, you talked about comparative density for a couple of projects today on redirect. One was the Richmond project, correct?
Yes.
Talked about that quite a bit yesterday, and that's not 40B, but it's under the zoning bylaw that allows additional density with an affordability component, correct? That was what we talked about yesterday. Did the Richmond development receive anywhere near the opposition that your project received?
No.
In fact, the project is currently underway, correct? Permitted, all appeals exhausted and underway.
Yes.
All right. And how about the fairgrounds project that you mentioned? That was not opposed in any way close to what your project was opposed with, correct?
From a comparative standpoint, I would agree with that.
In fact, that was the one that the town had approved the Board of Selectmen could convey the property for affordable housing, right?
Could you restate that, please?
The fairgrounds property was the one that the select board had been authorized to convey town property for affordable housing.
And that's not my understanding. Well, are you talking about Tacoma Green or the 31 Fairgrounds?
I'm not, I don't know. I don't know what you were referring to in your redirect.
Oh,
I was referring to the one approved by the town for the select board.
Okay, so the one that I understand was privately owned and is going to remain privately owned, but it's going to be funded through public funds.
Okay. And that one's underway as well, correct?
It's been approved. I don't believe it's underway.
Okay. A few of the issues you talked about today. First of all, on comparing apples to apples or apples to oranges for Beach Plum versus Surfside, you talked about the issue of unfinished space, correct? That the board denied your ability to, develop unfinished space within approved units. What are you getting at there about unfinished space?
So if you
go on at Beach Plum.
Yeah, so if you have an unfinished area in the basement or an unfinished basement, that is a wonderful potential space to finish without a lot of cost.
But as a licensed real estate broker, you're aware, or you're not, it's actually illegal to market a residential property at anything other than what is lawfully permitted for, correct? In terms of like a 3, 4, or 5 bedroom house?
Correct.
All right. In other words, you don't market something by saying, this is a 3 bedroom, but you may get a 5 bedroom out of it if you develop basement, right? That would actually be illegal, wouldn't it?
Of course, but you could market it as a playroom and all the other uses aside from a bedroom for that unfinished space.
Okay. The 92 unit project, today you said that you think it's not economically viable. Yesterday you said you agreed it was economically viable, right? Did you change your mind overnight?
No, I think yesterday's question was it economically viable at the time that we were discussing it with the board? And today's question is, would it be economically viable today with the imposed restrictions? So this
Okay.
is 2 years later with a specific list of conditions that didn't exist.
All right.
Well,
okay, so right. So I'll ask you some questions about what you just said about comparing beach plum and how you make it apples to apples versus apples to oranges. Before I get to that, just a few of the other issues we touched on, or your attorney touched on, are the $200,000 for traffic mitigation. You said that's based on 156 units versus 60 units, correct? Traffic mitigation.
Mr. Pucci, can you repeat that question? It was breaking up.
Yeah, it was breaking up for
Yes,
me as well.
Yes. The $200,000 traffic mitigation figure, you testified today that was based on 156 units versus 60 units, correct?
Correct.
But that's what you're seeking in this appeal, right? 156 units.
I think you were broken up, but if what I did hear was that's what you're seeking in this 156 units, and yes.
Yes. And actually, you're arguing that should be stricken, right? The full $200,000 mitigation figure for the 156 units now. You're arguing that should be stricken by the Committee on Appeal.
Mr. Pucci, we couldn't hear the beginning of that again. You're breaking up. So would you repeat your question?
Yes, you're saying that the $200,000 mitigation figure should be stricken in its entirety.
We're saying that the $200,000 mitigation amount is not appropriate for the 60 unit approved plan, which is what it's attached to.
So you don't have a problem with it. If you got 156 units, you agree that it should include a traffic mitigation condition of $200,000?
Well, that's what it was linked to initially, yes.
With respect to fire safety issues, I won't belabor the point, but did you file any rebuttal testimony in response to the pre-filed testimony of either the fire chief, Bruce Perry, or Ken Ho on fire safety issues, which were filed after your initial pre-filed testimony?
No.
Not of yourself, but of any witnesses?
No.
Now, with respect to the apples to apples comparison, first of all, let's look at the numbers a little bit. You just testified that I believe you said some of the sales listed on the document came after September 2020. Is that correct?
After September 24th, yes.
All right. So let's clarify that. First of all, again, the pre-hearing order says that the effective date for marketability issues is September of 2020. Do you agree with that?
I was told September 24th was the date.
Okay. Of the 7 sales for Beach Plum that are on the certified list, 3 of those sales were from September of 2020, correct?
Do you mind putting the list up?
Sure. I don't know what exhibit number that would be.
I believe it's exhibit 47.
Thank you.
One moment.
Three of them are from September 2020, correct?
Correct.
Of the three, using the correction of the $1.8 million sale, corrected to $1,840,000. Two of the three for September of 2020 are well over $2 million, correct?
Correct, because they have additional amenities that would,
Right.
justify that.
Okay. That certainly exceeds the $1.7 million multiplier that you used, right, to do your fair market value for the market rate units and 6-unit approved project. Regardless of whatever adjustment you wanted to make, those are significantly higher. In other words, they're over $2 million versus under $2 million, right?
Correct.
All right. Now, of the total 7 comparable sales, going from April of 2020 to February of 2021, 5 of those 7 exceed $2 million, correct?
5 of the 7 are, that's a 1, 2, 3, 4, 5.
All right. And regardless of whatever adjustments you're claiming apply to this, the hard figures are whatever the figures are. You were the one who chose Beach Plum, right? And we're just giving you the actual sales for Beach Plum during that time period. Is that fair to say?
Not at all. That would be analogous to saying, you walk into a car dealership, and because it's in the car dealership, they're all going to be the same price. I mean, there's a lot of distinguishing elements to the properties within this neighborhood that affect price.
And the math that I did actually, the math that I did yesterday on the fly with you actually sold the board short on this case, because if you have the average of those actual listed comparative sales, those 7 sales, you come up with an average of $2,106,086. If you multiply that by the 30 approved market rate units, you come up with $11,432,580, which together with the $4,826,454 inflation of the preferred sewer option leaves you with a delta pursuant to Lori Gould's pro forma of $6,113,174. Do you agree with that?
George, you're talking about some of these properties have 2-car garages and are fully furnished and have spas. I mean, you're trying to make a comparison here. If that were going to be a fair assumption, I'd have to add all sorts of costs on the other side. So you got
right. No, absolutely. So what I'm trying to determine is the credibility of your figure, the $1.7 million multiplier that you used in paragraph 74 of your testimony. You came up with a total projection of $51,750,000 in that, right? And that number was then plugged into Lori Gould's pro forma, correct?
Paragraph what? 73?
74.
74, yes.
Yeah, $51,750,000.
Right.
And when she performs the pro forma that's in evidence, she just plugs that into a certain portion of the pro forma, right? And then on the other side of the equation are all the project costs for building that project, right?
Correct, which don't assume garages or furniture or spas or many of the things that are influencing these numbers.
Yes. And what I'm saying is, if you use actual comparative sales for your comparison, if you use an average of them, and I understand you can't pick one out and just use that as a multiplier. You can't pick the low and you can't pick the high, and there has to be reasonable adjustments. So a reasonable way of doing it is to just average the sales, right? And use that figure and multiply it out. That comes to $11,432,580, which should be added to your $51,750,000 figure in paragraph 74, correct?
No.
Well, if that were true, that leaves you on a delta for your 15% profitability of only approximately $6 million, correct?
Yeah, but it's based
Mr. Hearing
on
Officer, I'm going to object. This is getting very repetitive. It's been asked and answered.
Sustained.
Well, let's put it this way. Your beach plum comparisons that you put in your pre-filed testimony, you actually didn't put on any list of actual sales, right? Just reflected those numbers and you put them on there, and then you said how you're going to use them as a multiplier is dependent on the apples to apples analysis that you're going to do. Is that correct?
correct.
George, you broke up multiple times in that. Can you restart that question?
I think the witness heard it. Maybe the stenographer can read it back. There's a question and answer on the record.
Can the stenographer read it back?
Let's put it this way. Your beach plum comparison, you actually didn't put on any list of actual sales, right? It's just reflected those numbers and you put those on there. And then you said how you were going to use them as far as the apples to apples. And that's what I got. You did break up a little bit.
Yeah, and the answer was?
I didn't get the answer.
Did you understand that question, Jamie?
Did.
Okay.
And I'll answer it again. I did in paragraph 73 provide a range. It's not specific to my analysis and you know how it influenced my my valuation.
Okay, and let's make sure we can hear this question. If I'm breaking up, I'll move to another section of my residence or something. These questions are important. So let's just ask you another question. On paragraph 773, the $1,695,000 sale and the $1,840,000.
Mr. Pucci, we can't hear you. Connection isn't good enough.
Let me move.
Can you move it somewhere?
Mr. Hearing Officer, perhaps we should take a 5-minute break to allow Mr. Pucci to relocate. We're getting close to 11 o'clock anyways.
Can we try this? Before we do that, let me just see if my other device, you can hear me better. I just need to be let in.
And I think you'll have to mute your other device, George.
Can you hear me better on this one?
If you mute, try muting the first one.
I did. Let me disconnect from that one. Can you hear me now?
It seems better.
All right.
We sort of interrupted here. Do you have much more here? It might be a good time to take a break. Or if you only have a little bit, we can go on.
I do just have a little bit, but I wouldn't mind a 5-minute break just so I can set this up.
Fine. Let's take a 5-minute break. It's 10:56, so we'll be back at 11:01.
Thank you.
Thank you.
Belabor the point, Mr. Feely. I won't take too much longer on this. It's fair to say on that for the multiplier that you reached, based on a range of $1.695 million and $1.84 million, it's fair to say that those are in fact the two lowest figures of the 7 comparable sales for beach plum from April 2020 to February 2021. Is that fair to say?
I could reference a chart if you would allow me, and I could answer that with definity. But what I can tell you is I think for sure in that time period, those are the only 2 properties that didn't have garages, didn't have spas, and weren't fully furnished. And so, you know, of course, that was what corrected them most into the direction of being comparable. And one of them was in September. I mean, you know, right before the cutoff day. I think it's September 19th.
And two others in September were $185,000 and $225,000 over the $2 million sales mark, right?
Which were very quantifiable.
All right. And just some quick follow-up to your question, your redirect about your experience with the town and this process. You claim that you're trying to meet the need for both affordable housing and year-round housing on Nantucket, correct?
Definitely.
All right. And we went over the town's efforts with respect to 40B issues yesterday fairly exhaustively, right? I asked you a bunch of questions about other 40B projects or town efforts.
About, yeah, creating rental units.
Yeah. And also funding for affordable housing efforts.
Yeah, there's been some good recent efforts.
And that was also addressed exhaustively in Tucker Holland's pre-filed testimony, which was filed previously on behalf of the board, correct?
It was addressed.
And just for because we're talking about you seeking to strike conditions. So say the committee was to decide to strike the condition you're talking about limiting you to 60 units. If the math figures that I gave you are correct, or those calculations, or at least they're reasonably close, even if they have to be adjusted further a little bit for apples to apples versus apples to oranges, about 12 condominium units would do it for you, wouldn't it? That would bring you to 32.
Objection again, Mr. Hearing Officer. He's speculating about a development that has not been proposed or approved.
No, I'm talking about the issue is this is an approval with conditions. The developer has to show that the conditions render the project uneconomic, and then we address local concerns. And so I'm probing that. They have a problem with 60 units. Well, let's look at it. Let's look at what's economic. If you accept that it's not economic at 60, it's certainly relevant at what point you reach it being economic. And again, we've raised an appellate issue about being saddled with a project for the first time on appeal. And I'm stuck with the decision of defending a decision based on a 92 unit proposal. And the economics and rejiggering the numbers a little bit are certainly relevant.
Mr. Hearing Officer, the HAC regulations are very clear.
Excuse me. I think this is really kind of right on the margin as to whether it's relevant or not. And if Mr. Feely has done the math and knows, I would be surprised if he's done the math on these things. But if he either has done it or he can respond to it fairly based on his experience, I'm going to allow the question. Could you restate it, please, or have the stenographer?
Sure. Yeah, and I just have a couple of questions on it. I'll restate it, and I'll just get to the point. So say hypothetically you can. It's economic at 30. It's economic at 40 single-family residences as approved. That would be 30 market rate, 10 affordable, and then you have another 12 condo units. Which you could put in different configurations on the site to give you 32 condominium units total. So let me just ask you, and with respect to your concern about affordable housing and year-round housing, that would have real-world consequences for at least 42 families who might otherwise be shut out of the Nantucket housing market, correct? And that would consist of 32 condominiums, a quarter of which are affordable, and 3/4 of which are intended for a less than $1 million price point, and 40 single-family houses, 10 of which are affordable, right? Real-world consequences for 42 families.
Mr. Hearing Officer, I think there's about 4 or 5 different questions in there. I'm not sure what exactly he's supposed to be answering.
Whether that would have real-world consequences for 42 families otherwise shut out of the year-round Nantucket housing market.
Well, I absolutely agree that that every home that's created on Nantucket, home ownership opportunity for the year-round folks makes a difference. I mean,
and when the appeal process started at the HAC, you were offered, in fact, your counsel was instructed by the pre-hearing, by the pre-conference order to confer about alternative dispute resolution. You, in fact, refused any type of alternative dispute resolution and have refused to have any dialogue with the town about a potential compromise.
Objection, Mr. Hearing Officer.
I withdraw the question. Thank you very much. That's all the questions I have.
Thank you. Any to follow up, Mr. Haverty?
No, Mr. Hearing Officer.
Thank you very much. Thank you, Mr. Feely.
thank you, Hearing Officer Lowy.
So who do we hear from next? And how many witnesses are you planning to examine, Mr. Pucci, and who's next?
Just one more witness, Mr. Lowy, and that would be Brian Madden. And I'm going to turn that over to my colleague, Attorney Braun.
Thank you. We have Mr. Madden in the room. Can we put him on the screen?
Perfect. Great. Good morning, Mr. Madden. Thank you for your time today. My name is Devin.
I don't see him, so maybe Mr. Madden, can you just say
He
your
is
name?
on.
I see him, yeah.
I'm here.
All right, I don't see you. There, now I see you. Good, thank you very much. Welcome, Mr. Madden. Before you start, would you raise your right hand, please? Do you solemnly swear or affirm under the penalties of perjury that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, thank you. Good afternoon, Mr. Madden. My name is Devin, and with Mr. Pucci, I represent the board. And I just have a few questions about your work on this project and your pre-filed testimony. But if you have any issues seeing or hearing me at any time, please just don't hesitate to interrupt and let me know.
Will do.
All right. So by way of brief background, you hold a Bachelor of Science in Biology and Environmental Studies. Is that correct?
Yes.
And since attaining that degree, you've been employed as a wildlife scientist for LLC Environmental Consultants?
Since 2002. Full-time.
Okay. And in that role or otherwise, have you had any experience working on Chapter 40B developments before Surfside?
I have, yes.
And were those on Nantucket?
Yes, I permitted Beach Plum Village.
Beach Plum. And do you have any other experience working with property owners on Nantucket?
Yes, quite extensively.
And is that before the Concom or?
Both through Conservation Commission and through the Natural Heritage Endangered Species Program. I participated in some planning board and some ZBA meetings as well.
Great. So you're pretty experienced with real estate work on Nantucket?
Yes.
Great. And have you done any other work on Nantucket then since you were engaged by Surfside?
Yes.
All right. So you were first engaged by Surfside in, I think, August of 2017. Is that correct?
Correct.
and that was to provide rare species consulting services for the proposed development at South Shore Road for Mr. Feely?
Yes, rare species due diligence work prior to property acquisition.
Okay, so when you were first engaged by Surfside, you conducted a site evaluation?
I did.
And that was prior to Surfside acquiring the property?
Correct.
Okay. So at the time you did your site evaluation, I think you said it was in August 9th, maybe, of 2017?
Yes.
You didn't know what state-listed species were mapped at the Surfside site, right?
Actually, I had worked on the site for another client previously, so I was aware of what it previously was mapped for.
Okay, but it said in your pre-file testimony that you got the state-listed species from the National Heritage and Endangered Species Program?
Yes, we filed on August 10th and received the letter on in early September, confirming the species list.
Okay. After you received that information from NHESP, did you ever go back to the site?
I have, yes.
When was that?
I've been back several times. I don't have specific dates that I can easily recall.
Okay. But at some point in your review, you confirmed that the site is located within a priority habitat map for rare species, correct?
Correct. In our initial due diligence work, we reviewed the Massachusetts Natural Heritage and Endangered Species Priority and Estimated Habitat Mapping per MassGIS data layers and confirmed that it was within map priority habitat. And then we had filed that information request to determine what currently the site was mapped for, or what species have been found in the vicinity of the site.
Right, and so NHESP has designated the site as a priority habitat map and then sent you the list of species that were present on the site.
Correct.
And it's your understanding, obviously, that sites located within the priority habitat map must be reviewed by the Division of Fisheries and Wildlife for compliance with Endangered Species Act?
Yes, for any non-exempt work activities.
And this is a non-exempt work activity, right?
The project, yes.
And did Mr. Feely ever ask your opinion about whether habitat or species concerns would impact the proposed project before he closed on the property?
Yes, we did review species impacts and state-listed rare species concerns and permitting requirements based on preliminary conversations with Natural Heritage at that time.
And so what was your advice to him at that time?
We reviewed what the permitting requirements would be, essentially complying with performance standards under MISA regulations, whether or not the scale of the project would result in mitigation requirements. At that point in time, prior to acquisition, I don't believe that there were any conceptual plans rendered at that point.
Okay, but so as far as the developer was concerned, this project was going to move forward, regardless of sort of what was found at the site at that time.
Based on the preliminary information we received by Natural Heritage, that was relayed to Mr. Feely, and he ultimately did make the decision to move forward with the site.
Okay, and that's your actual MISA review didn't start until about like a year after that, right?
Correct. Yeah, the normal process is to engage Natural Heritage in preliminary consultation in the early design stages to address any state-listed rare species concerns up front.
Got it. So how big is the Surfside site?
13.56 acres.
Okay. Oops, sorry. And so the majority of that, I think 4 parcels, is undisturbed land, correct?
Yes, there's some minimal encroachment from surrounding properties, but yes, it was undeveloped.
And how much of that 13.56 acres will be preserved in its undisturbed or natural state?
As part of the current proposal?
Correct.
I believe it's 1.29 acres.
1.29 acres.
Yes.
Okay. And not the it's not the 12.72 acres.
Oh, did you say undisturbed or disturbed?
Well, so how much of the site is going to be clear cut?
Okay. The project footprint that was included within the MIPA filing was for 12.27 acres.
Right. So that leaves, maybe my math is off, but that would leave like 0.84 acres left undisturbed, right?
Yeah, it seems about right.
More or less. All right.
Actually, sorry, can I correct that? 1.29 acres is undisturbed. That gets you to 13.56.
Gotcha.
Thank you.
And so, you had testified, I think, or in one of your exhibits, a lot of the site is currently pitch pine and scrub oak habitat. Is that correct?
The site is dominated by partially open pitch pine habitat with a variety of shrub species in the understory, one of which is scrub oak.
And it's your understanding throughout this project, I'm assuming, that the northern long-eared bat is one of the species that relies on pitch pine and scrub oak habitat for its feeding and breeding.
Can you clarify that question a little bit?
Sure. My question is just whether throughout the course of this project you've come to understand that the northern long-eared bat is a species that relies on pitch pine and scrub oak habitat for its.
Okay. Yes, I'm aware that the northern long-eared bat does use pitch pine trees as maternity roost trees.
Awesome. All right. So back to the undisturbed vegetation. Was there any thought to maintaining any of the native vegetation on this site?
Yes, we had talked about preserving a perimeter buffer area that was contiguous with a portion of the Sachem's Path development to the north at a 25-foot buffer.
Okay. Was there any effort by you or maybe anyone else at Surfside that you're aware of to contact any local organizations that were studying northern long-eared bat habitat and what could be done to mitigate any loss of that habitat on the site?
I don't believe there was any direct consultation.
Why not?
All of the consultation was through Natural Heritage, who regulates state-listed rare species habitat protection.
And in the course of your review, did you ever look into or request whether there are any local regulations or requirements with respect to protecting endangered species on the island? Or just the NHGSP guidelines?
Yeah. My review was focusing on the MISA regulations.
Gotcha. Are you aware that relatively simple measures could be taken to maintaining pitch pine trees and erecting rocket roost bat houses to try and reduce the impact to the natural species and specifically the northern long-eared bat on the site?
I'm aware that man-made structures have been used.
Gotcha. All right. So in your pre-filed testimony, you mentioned at some point you began working with Jesse Leddick.
Yes, he was the primary project reviewer analyst at Natural Heritage.
Okay, and so did you know him from before, or did you just come to know him from your work on that project?
We've worked together on many projects throughout this Commonwealth.
Okay, how many?
Take a while to count. Certainly, quite a bit.
Like 50 to 100?
Maybe over the years, approaching that number, possibly.
So how many years have you worked with him?
Let's see. I think he's been at Heritage for certainly greater than 5 years, maybe 7, 8. I don't recall his employment.
Fair enough, yeah. So you mentioned that you had maybe had some preliminary discussions with him before you did the MISA filing. Could you just elaborate a little bit on some of the substance of those discussions?
A discussion of what mitigation requirements would ultimately be required.
And at the time, what was your understanding of that?
Prior to the 2018 Moth study conducted by Mark Mello, the site was mapped for a variety of rare moths, some of which were special concern and threatened, that carry different mitigation ratios.
Okay, but at that time, you weren't aware of any other species other than those 6 listed or given to you that were on the site, and that is including the coastal Heathland cutworm moth that was later discovered?
Correct. Yeah, I rely on the list that Heritage provides.
Okay, so you never did a study for the coastal Heathland moth on the site?
No, a moth expert, Mark Mello of the Lloyd Center for Environmental Studies, had performed a partial survey in 2016, and then a supplemental one in 2018 for the applicant.
Do you remember what were the results of the study then in 2016?
In 2016, he found 3 individuals of the coastal Heathland cutworm, that being the only state-listed rare species.
Okay, but that wasn't. Okay, gotcha. Let's see. So when did that information about the coastal Heathland cutworm end up getting submitted? Was that after the 2018 study, not at the 2016 study? And why not?
I wasn't involved with the project with the 2016 survey, but I believe Heritage had a record of that survey report.
Okay. When you did your study, were you aware at the time of the new research and recent discovery of the northern long-eared bat on Nantucket?
Through the process, I became aware of the bat discussion, yes.
Okay. So Mr. Mello at some point, obviously in 2016 and 2018, was given full access to the site to conduct a field survey for, I think, butterflies and moths, right?
Yeah, specifically moths, yes.
So but you didn't do a field study for bats?
No, the site was not mapped as priority habitat for northern long-eared bat.
But, okay. And did anyone on the island from local conservation groups, specifically I think Danielle Odell, request access to the site to study that, given the recent discovery of them in that area?
Yes, I believe access was requested through the select board.
And she wasn't given access to study the site, correct?
Correct.
So if the coastal Heathland cutworm moth was never on the list of original species for priority habitat 8, and it was later determined, as we know, to be a take after the field survey by Mr. Mello. Would you agree that that same process might have occurred for the NLEB had she been allowed on this site?
Can you clarify?
So we understand that the coastal Heathland cutworm moth was later determined to be a take on the site, right?
Correct.
After its discovery in larger numbers by Mr. Mello.
The 3 individuals, yes.
Sure. But would you agree that the same process may have occurred for the NLEB, the northern long-eared bat?
I can't speculate on what those results may or may not be.
Fair enough. But if the Surfside site were mapped for NLEB, had Danielle Odell been able to access the site, would that have resulted in a take of the species?
Not to my knowledge. I believe Heritage is on record in their final decision that was included in my pre-filed testimony that if a maternity roostery was documented on the project site, that they would require the time of year restriction for no cutting in June and July. And with that compliance, it would not result in a take. And the applicant had already voluntarily proposed not to do any cutting in June and July.
Right. Did you memorialize that in writing anywhere, the applicant?
Sorry, I got a little feedback. Did I invite it?
Sorry, did you memorialize that agreement not to do any cutting in June and July anywhere?
Yes, I stated that on record with the ZBA at a public hearing on October 30th, 2018, I believe, and it was included within a letter from LEC myself to the zoning board on November 6th, 2018.
November 6th. Thank you. So I'll move on. Just one sort of quick question. I guess given what, I don't know if you've reviewed the Odell and Dowling study, but given what they learned so quickly about the type of habitat that the bat uses on Nantucket, which, as you agreed, is the exact habitat that's on the Surfside Crossing site, I'm just curious, in your professional opinion as a wildlife scientist or biologist, are you not concerned about the possible impacts to the northern long-eared bat due to that excessive clear cutting?
Not with implementing those time of year restrictions, no.
If you think that if they don't clear cut in June and July, that will be sufficient?
Based on state and federal regulations, impacts and take would be avoided.
All right, so what is the significance of a take determination by NHESP?
What is the definition of a take?
Yeah, significance of it, what's its impact? Just explain it a little if you could.
Yeah, a take as defined under the MESA, Massachusetts Endangered Species Act regulations, can be either the direct harming or killing of state-listed rare species, interference with life behaviors like feeding, breeding, migratory activity, overwintering, or habitat loss.
All right. So projects that result in a take determination are allowed to proceed only if they meet certain performance standards for a conservation and management permit. Is that right?
Correct.
Okay. And a project can proceed only if there's a long-term, I guess, conservation plan or mitigation plan for the impact on that species, right?
Correct.
Okay. Can you explain how the cutworm moth meets the performance standards for a conservation and management permit?
Yes, so the coastal Heathland cutworm is a species of special concern which carries a mitigation ratio of 1.5 to 1. In other words, for every acre you alter, you have to protect 1.5 acres. And in this application, Heritage, through those discussions, agreed that off-site mitigation would be required or allowed, and that is achieved through either direct land protection, execution of a conservation restriction, or conveyance and fee to an approved conservation entity, and or some financial contribution to benefit the impacted species through that will help fund conservation research, recovery, habitat management, or land protection.
Okay, so with that 1.5 to 1 ratio, I think you came up with, or it equated to like 20.34 acres of required mitigation for that species?
Correct, and that was based on the entire project site, even though the entire site wouldn't be cleared.
Okay, and you proposed that the 20.34 acres be located entirely off-site, right?
That is what is proposed, and will be reviewed under the conservation management permit application.
Okay, so in your view, off-site mitigation means off the Surfside Crossing South Shore Road site, right?
Correct.
Would it mean, it wouldn't mean like off the island of Nantucket?
I think the applicant has stated his commitment to the mitigation being on island. Any details of the mitigation proposal would be reviewed through the CMP review process.
Okay, has the applicant, or I guess yourself on behalf of the applicant, identified where this 20.34 acres of offsite mitigation could occur on Nantucket?
That will be reviewed under the CMP review process.
But at this time, you haven't found anywhere on Nantucket that would suffice for that.
That process hasn't started in earnest.
Okay. Is it your opinion that that you could find 20 acres like elsewhere in Massachusetts off the island, and that would be sufficient for this species?
I have not had any conversations with Heritage on that subject.
But you proposed the offsite mitigation, right?
Correct.
Okay. And just to, I guess, confirm, but you don't know where that offsite mitigation is going to be.
It will be finalized through the CMP review process.
Okay, and maybe silly question, but so the coastal Heathland cutworm, I guess by its name, survives just in coastal areas, right?
Correct. It has somewhat of a broad habitat needs, or it's typically associated with habitat that's kind of, it varies throughout Nantucket.
Okay, like it couldn't survive, I guess, in like Western Massachusetts where there's no coast.
I don't know if the species has been found out that way. Certainly there are some habitat conditions out in the Connecticut River Valley that certainly there's pitch pine out there, and there's heathland shrubland habitat, but I'm unaware of it. I haven't worked on any project with that species out in Western Mass.
Okay, would you think that the 20-acre site mitigation plan could be like outside the state? And you mentioned the Connecticut River Valley. Is that in Western Mass or in Connecticut?
That's in Western Mass.
Gotcha. But is it your opinion that this mitigation could be outside the state of Massachusetts?
I don't believe the MISA regulations allow for that.
All right. Just, are you aware of any project that has allowed mitigation entirely off-site or entirely off the island of Nantucket for a species?
For a project proposed on Nantucket?
Yes.
Although I don't know all the details, I believe the Richmond project did have some mitigation that was off island, possibly, I think, on Martha's Vineyard, but I don't know all the details of that. All the projects that I've worked on, all the proposals have been for mitigation on island.
Right. And if there was, I don't know that project, but if there was some off-site, would you agree there was also likely an on-site conservation restriction? There's never been an entirely off-site conservation restriction, if that makes sense.
I'm unaware if the Richmond project had an on-site restriction.
Oh. Okay. So I guess last question. You haven't found a 20-acre site that is listed as priority habitat for cutworm moths?
Yes, we haven't found one yet.
Gotcha. Okay. So in your opinion, once the 13.5 or so acres site is clear cut, will any of the species that we've been discussing be able to live there in their current numbers?
Within the project development footprint or the perimeter buffer that will not be disturbed?
So the 12.72 acres of clear cutting.
12.27. Not within the project footprint.
Even within the perimeter buffer areas, do you think is it your opinion that they'd be able to remain there in their current numbers?
I believe the perimeter buffer could provide some habitat.
Some habitat. But you'd agree that the removal of all the vegetation on the site, perhaps other than perimeter buffers that were imposed as a condition, would end any possibility of the coastal heathland cutworm living there in their current numbers?
Within the development footprint.
Where they currently are in their current numbers.
The 3 individuals that were found on site, they would not be found within the interior of the project footprint, the development footprint.
Okay, and so would you agree that the removal of all the vegetation on the site will end any possibility of the northern long-eared bat roosting there?
Within the cleared areas, but I don't have any knowledge of any roosting on site.
But the roosting on site was never studied, correct?
Heritage did not require that.
And Danielle Odell was denied access to study that, right?
She was denied access, yes.
Okay. Would you agree that the removal of all the vegetation on the site would end the possibility of the 6 other state-listed species remaining there in their current numbers?
Those 6 remaining species.
I'm sorry, could you repeat that question again, please?
Of course. Would you agree that the removal of all the remaining vegetation would end any possibility of the 6 other state-listed species from remaining there in their current numbers?
The 6 remaining moth species have not been found on site.
But they're mapped in that site as a priority habitat.
They were mapped as being documented somewhere in the vicinity of the site. The moth study that was conducted did not find those 6 other species.
Okay, but they're listed on the NHESP as being on the site or in the vicinity of the site in that priority habitat map, right?
Documented within the vicinity of the site.
Right. Okay, so in your opinion as a biologist, wildlife scientist, would you agree that reduced light output from the site would cause less disturbance to any of these ecosystems or ecologies?
It's a little broad. Could you clarify or refine?
Would reduced light output from the site, say, cause less disturbance to any northern long-eared bat living in the vicinity of the site or on the site?
I'm not a bat expert, so I couldn't speculate.
But you're a rare species expert, right?
I'm a wildlife scientist who has rare species experience, yes.
Okay. I mean, I guess common sense, bats are nocturnal, right? They avoid light and certainly artificial light.
Again, I'm not a bat expert, but sounds
Okay.
appropriate.
You'd agree with me that, or you wouldn't have any reason to disagree with me, I guess, that studies have shown that the projection of artificial lighting near the habitats disrupt their feeding and breeding patterns in the area.
Objection, Mr. Hearing Officer. This has been asked and answered.
Sustained.
Gotcha. So in your opinion, would reduced noise, I guess, caused by, say, people or traffic, air conditioners humming, perhaps spa jets, would any of those things cause less disturbance to these ecosystems or ecologies we've been discussing?
Again, I'm not a bat expert, so I couldn't speculate. Relative to the rare moth, I'm unaware of any noise impacts on moth species.
Okay, I understand that you're not a bat expert. I guess common sense, bats use sound, or I guess echolocation, to navigate and hunt, right?
That's my understanding.
So any increase in ambient noise levels from the site would interfere with their ability to do that and survive?
To what degree, I could not speculate.
Fair enough. And so I know you're not a developer or I guess a bat expert, but would you agree that reducing the scale of the site by building fewer units would serve to reduce the amount of noise, light, traffic, overall clear cutting of the natural environment for these species, and therefore, I guess, reduce the disturbance to them?
Could you clarify? I couldn't quite follow the question.
Okay, sure. So would you agree that reducing the scale of the site by building fewer units would help reduce the amount of noise and traffic and light and amount of clear cutting that would be required, that would cause less disturbance to the species we've been discussing?
I think it's intuitive that a smaller project would result in less disturbance.
Right. So obviously, I mean, you'd agree with me that building 60 units versus 156 units would lessen the overall impact on these threatened species that rely on the natural environment, obviously.
To what degree, I would not know.
Sure, but as a common sense principle, I mean, it would involve less of an impact to the natural environment. I think you agreed with that.
Less units. I don't know, specifically a smaller footprint. As I said previously, a smaller footprint would result in less disturbance.
Sure, thank you. Mr. Presiding Officer, I don't think I have any further questions, but I would hope to maybe just have like a brief 5-minute break to confer with my colleague, if that would be okay with everyone.
Sure. We'll, it's 1:15 exactly, so we'll come back in 5 minutes at 11:50.
Great, thank you.
Thank you.
Good morning, Mr. Madden.
Good morning.
I believe you covered this already in your earlier testimony, but did LEC conduct a review of the Massachusetts Natural Heritage Atlas to determine the presence of state-listed rare and endangered species for the Surfside Crossing project?
Yes, in early due diligence, we reviewed the mapping for the site and filed that information request with the Natural Heritage Program.
And is this typically what is done prior to commencing a project to determine whether there are concerns with rare or endangered species on the site?
It is typical for LEC to engage with natural heritage early in the analysis process to understand state-listed rare species concerns and permitting requirements. And we, on all projects, consult with mapping before going out to a site and file information requests as well.
Right. And did the Division of Fisheries and Wildlife ultimately issue a take letter with regards to this project?
They did.
Okay, and can you explain what was contained in that take letter?
Yes, the October 19, 2018 letter stated that the project would result in a take of the coastal Heathland cutworm.
And did the take determination issued by the Division of Fisheries and Wildlife include northern long-eared bat?
No.
And did the take determination include New England blazing star?
No.
Is there an appeal process associated with the take determination made by Natural Heritage?
Yes, the take determination was appealed by the town and the land council.
Okay, who is that? What is that appeal process exactly? Who does the appeal get filed with?
With the Division of Fisheries and Wildlife.
So it's an administrative agency appeal?
I believe so, yes.
Okay. And so you stated that the town and the Nantucket Land Council appealed the take determination?
Correct.
I might just object, as this, I don't think I touched on any of this in the scope of the cross, but
I'm going to overrule the objection. I think there was enough discussion of the take that this is appropriate.
Thank you. And has a decision been issued on the appeal that was filed by the town and the Nantucket Land Council?
Yes, the director of the Division of Fisheries and Wildlife issued a final decision affirming the recommended decision by the presiding hearing officer, affirming Natural Heritage's original take determination specific to the cutworm.
And have you reviewed that decision from the Department of Fisheries and Wildlife?
I have.
Right. And Ms. Loftus, can you please put up Exhibit 35G?
Yes, one moment.
And specifically, I'm looking for page 29. So, Mr. Madden, do you see, that's kind of difficult to, can we expand that? Yes, thank you. This page 29. Can we go down further, please? Okay, that's good right there. So, Mr. Madden, can you tell me how many maternity roost trees were found in Nantucket in Ms. Odell's study?
I believe to date that there are 8 maternity roost trees.
And in how many locations? And how many locations were those trees found?
I believe, two locations somewhat close to each other, but far west of the project site.
Thank you. And if, Ms. Loftus, if you could turn to page 45 of Exhibit 35G. And Mr. Madden, what does the decision of the Division of Fisheries and Wildlife state with regards to the sufficiency of acoustic data for the mapping of priority habitat?
That it's not evidence for an occurrence and is not utilized for the mapping of priority habitat.
All right, thank you. And have there been any verified observations of the NLEB within 150 feet of the property?
Maternity roost trees, not to my knowledge.
Okay. Have you been presented any evidence of verified observations within 150 feet of the property?
Of maternity roost trees, no.
Are there any known winter hibernacula within 0.25 miles of the property?
Not to my knowledge.
All right, and you stated in your earlier testimony that Surfside Crossing has agreed to restrict tree removal so that no trees are removed between June 1st and July 31st each year, is that correct?
Yes.
What is the purpose of this sort of time of year restriction on tree cutting?
The federal and state, well, the federal 4D rule essentially prohibits tree cutting within a quarter mile of documented northern long-eared bat hibernacula, or cutting of documented maternity roost trees in June and July during the pup season.
So would this restriction address concerns with regards to the NLEB, even if there was documented maternity roost trees within 150 feet?
I believe so.
Okay. Is the applicant required to obtain a conservation management permit from the Division of Fisheries and Wildlife?
Yes.
And why is that?
For the take of the cutworm.
All right. And as part of that conservation management process, could the Division of Fisheries and Wildlife impose a restriction on the time of year of tree cutting?
I believe so.
All right. In your professional opinion, can the project comply with applicable federal and state requirements relating to rare and endangered species?
Yes.
Okay. No further questions, Mr. Hearing Officer.
Thank you. Mr. Madden, may I ask you one last question? And it may be difficult for you to answer, and it may actually be something that the lawyers can clear up, but it's not that evidentiary in a way. But let me ask you first. The very last question asked by Ms. Brown referred either to an open space plan or a bylaw. I'm not sure which. You answered saying something about a bylaw, a local bylaw with regard to endangered species. Do you know if there is such a bylaw?
No, I'm not aware of any. Yeah, I meant to say plan specific to the question that was referenced.
Okay. Thank you. That's what I thought. Perhaps you misspoke. I wanted to be sure.
Thank you.
I also, Ms. Brown, do you have anything further for recross?
Maybe just briefly. Mr. Madden, you didn't personally search for maternity roost trees on the site or within the 0.25 miles of the site, did you?
No, it was not requested by Natural Heritage.
And you, or I guess the applicant, denied requests to search for the northern long-eared bat or maternity roost locations on the site, right?
The property owner.
In your professional opinion, are you not concerned about that there could be, given I guess that the research is in its infancy still on Nantucket, that there could be maternity roosts on the site?
My understanding that with implementing those time of year restrictions, that impacts and takes are avoided.
But would you agree that a survey of the site to confirm that there are no known maternity roosts would be, I guess, diligent or appropriate for an endangered species like the northern long-eared bat.
Not in this case when the site is not mapped as priority habitat for the northern long-eared bat.
Okay. I don't have anything. Thank you.
I have nothing further, Mr. Hearing Officer.
Thank you very much. Thank you, Mr. Madden.
Thank you.
All right, so it is lunchtime, but tell me what's next. Is there more testimony to be heard?
No, we do not intend to cross-examine any other of the applicant's witnesses, as I had previously notified Attorney Haverty.
Okay, thank you. Mr. Haverty?
Mr. Hearing Officer, we don't intend to call any of the board's witnesses.
So that much quicker.
Sorry, Mr. Hearing Officer, you're breaking up.
I'm sorry, I missed you, what you said, Mr. Hearing Officer.
So we had thought we might do it in 3 days, but it looks as though we've done it in a year and a half, and a day and a half, correct?
Don't look more like a year and a half.
So I think we should talk about the briefing schedule. We have a site visit scheduled for April 30th. I think by then, let's hope the COVID situation will be enough under control, and I think I'll be comfortable with it. What's your preference with regard to briefs? What we normally do is set a date for simultaneous filing of briefs 30 days after the transcripts are available.
That sounds good
so,
to
Mr.
me.
Hearing Officer, do we want to tie it to the date of the site visit? I mean, I don't know if we're going to get the transcripts before the site visit or not.
Well, my recommendation is to just, but it's up to you. I mean, we could have it go a little later. I won't ask the stenographer to commit to anything, but often you're talking more closer to a week than a month. So I would expect that we're talking a week or so before the site visit, probably something like that. My inclination would be to go ahead on that schedule, but you tell me what you want to do. Would you?
The only thing that I would want to do is do the briefing at least after the site visit, even if we got the transcript tomorrow. I would at least want the site visit to go forward before the briefs are due. I don't feel strongly about it. I just don't see how you can consider the record complete until that site visit goes forward, but I'm open to suggestion as well.
So I think you're both saying the same thing, and looking at the calendar, it seems to me, I don't know why my calendar isn't coming up. Let's give you a couple of days after the site visit. The site visit is on a Friday, and as I say, I do think you want to keep these things moving. So let's just say that briefs are due on Tuesday, the 4th of May.
That's fine, Mr. Hearing Officer.
What day of the week is that?
Tuesday, the 4th of May. The briefs will be due. And as I said, I'm sure there'll be no problem with having the transcripts well in advance of that. If there is some, you can contact our clerk's office and we'll straighten it out. But I'm sure there'll be no problem. There'll be at least 30 days to review the transcripts. And once again, May 4th, Tuesday, for following the briefs. April 30th, 10:30 a.m. for the site visit in Nantucket. And what we'll do is, I'll plan to take the ferry, but we'll just meet at at the site at 10:30. My understanding is there's a ferry that arrives a little bit after 10, so that should allow for plenty of time. I'll see you all then.
Mr. Lowy, one question really more on behalf of the public, because this has been must-see TV, and people will be wondering if they can go to the site visit. I just am anticipating that, and I just wanted to throw it out there to you. I don't want it that you're not expecting anybody there and there's 100 people and how we deal with it. But do you have any
my understanding
guidance?
is, it is customary to allow the members of the public on the site visit. For the people that are watching right now, you should know that the site visit is not evidentiary in any way. It's not really part of the hearing in that sense. There is no testimony taken.
You froze again.
After some time, as I say, the lawyers always.
I'm sorry, you froze up again.
Yeah, I understand. I'm pausing now, hoping it'll come back. My connection isn't great either. Am I back now?
I guarantee you, I guarantee you, the public is listening to you right now. So yeah, it's helpful for them to hear that guidance.
Absolutely. So, as I say, the lawyers certainly always understand this, but sometimes the parties or members of the public or so on don't realize that this is not an opportunity for any evidence. So therefore, there really will be no explanation other than my asking the lawyers perhaps to point to where a boundary is or to point to something that is in testimony. I mean, someone might say, I know what a pitch pine is, but if I didn't know what a pitch pine is, I might say to somebody, point out a pitch pine to me. But although I'm not even sure the bat issue is properly before the committee, in that that's been addressed in the pre-hearing order, the pre-hearing ruling. So we will go ahead with that site visit. It's customary to allow the public to watch, to come along, but as I say, there really won't be any discussion at all. It'll just be probably when we're there, we'll decide, but probably 20 minutes, something like that. Walk around the site a little bit to the extent it's possible. It seems to me that usually on a site like this, you can't you can't go through all the underbrush, but you can walk along the site a little bit and get a sense of what the site looks like. And people can point out while we stand on the street which direction the different developments are. Although I think I have a very good sense of that from having looked at the plans. So thank you for raising that, Mr. Pucci. Mr. Durensis?
Just wondering if you would entertain anything from the participants in connection with the briefing schedule.
No, I believe your opportunity was to present a statement, which was quite effective. And since we're not parties, I don't really see any reason to do that. In some ways, I don't. Part of it is I don't really want to lead you on, in a sense. I mean, it feels to me as though many of the issues have already been addressed in the pre-hearing ruling. And I guess if you feel very strongly that you want to file some sort of brief, I feel like I guess you can do that. Do Council, Mr. Haverty or Mr. Pucci, do you have any feelings about whether the interested persons should be able to file briefs?
Mr. Hearing Officer, my understanding is that interested persons are not allowed to file briefs under the regulations.
My position would be the more the merrier. I'm happy I would agree to the submission of briefs from those other parties.
Well, Mr. Haverty, it's not specifically provided for in our regulations. Our regulations leave it to the discretion of the presiding officer, the hearing officer, to determine on what basis the interested persons will participate. And so therefore, I'm going to permit either or both of the Nantucket Land Council or the residents to file briefs. And so you already heard what I had to say. I'm trying to be helpful here. I'm not sure how useful they'll really be to me or to the committee, given the ruling that is already part of the record. But on the other hand, there is a situation where some testimony that is of marginal relevance as well. And as an administrative body, we always take the position that there's no such thing as too much information. But we'll look at it. If it's not relevant, it won't become part of the decision. But if you're interested in filing, you have permission to do so.
Thank you.
It also occurs to me, I often offer people an opportunity to make a closing statement, but it seems to me here, based on that, I didn't expect it, but I'll say that again now too. If Mr. Haverty or Mr. Pucci, if either of you would like to make a closing statement, you may do that.
I will defer to Mr. Pucci if he wants to do closing statements. I'm prepared to do one. If not, then I can skip it.
And Mr. Lowy, the only closing statement I have, and I don't mean to be corny, we're very appreciative of the hearing that you conducted. I compliment your professional staff, including the stenographer, and getting the exhibits up online. We're truly appreciative of your efforts, and that's from somebody very technologically challenged. So I appreciate the way this hearing was conducted. Thank you.
Well, thank you. And to say, everybody was very professional, very polite, and very patient with the technology. None of us enjoy this remote world very much, I don't think. So I thank everyone for their involvement. Is there anything else?
Thank you to everyone.
In that case, I'll close the hearing and we'll meet again on Nantucket for the site visit. Thank you very much.
Thank you.
Thank you.
Thank you.